last month, the court ruled in a 5-4 decision that the Second Amendment guarantees a right to have guns for self-defense in the home, even if gun ownership is completely unconnected to the need for a well-regulated militia. So although certainly the court's decision was a historic revision of Second Amendment law, it's important to understand how limited this decision is in a couple of important respects. First of all, the ruling applies only to the District of Columbia and by implication to the federal government. So it means the district can't ban handguns, it means Congress can't ban handguns. But in a footnote, the court said that it was not deciding the separate question of whether the Second Amendment applies to states and other localities, leaving intact long-standing Supreme Court precedent dating back to the 1870s that the Second Amendment does not apply to the states. So this decision has no direct impact on gun bans, for example, in Chicago or other local jurisdictions, although as we'll talk about a little bit later, that is probably the next big front in this battle. Second, the majority opinion finds that the right to bear arms is, quote, not absolute. And Justice Scalia said that the right is, quote, not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. And then, in what I think is the most extraordinary part of the majority opinion, Justice Scalia actually goes through a litany of specific gun regulations and says these regulations are presumptively constitutional, which is highly irregular for the Supreme Court to even comment on the constitutionality of laws and regulations that are not actually before it. The litany included such restrictions as limitations on carrying concealed weapons, prohibitions on gun possession by felons and the mentally ill, laws imposing conditions on the sale of firearms, which of course could include background checks and other regulations, laws forbidding guns in sensitive places like schools and government buildings, bans on particularly dangerous and unusual weapons, which of course could include machine guns, assault weapons, .50 caliber sniper rifles, and laws regulating the storage of firearms to prevent accidents. And then in a very interesting footnote, Scalia added that our list, quote, does not purport to be exhaustive. So basically all the court is saying here is that the particular gun ban at issue in this case may run afoul of the Second Amendment, but it is reassuring the American people that a wide range of gun regulations would not run afoul of the Second Amendment.